Next floor goes to Mr. Geoffrey Alagaratnam. He is a presidential counsel with over 40 years of legal practice. He was the past president of the Bar Association of Sri Lanka in 2015. He is the director in Law and Society Trust. He's a member of the Center for Study of Human Rights in University of Colombo, the lecturer and examiner in the same faculty. He's a member of the faculty of board of the Faculty of Law in University of Colombo, and he has very keen interest in areas of public law and public interest litigation and constitutional governance issues. He's a very good speak person, even from the political and human rights perspective, widely known within the country.
Thank you very much. After what the two eminent speakers said, as a lawyer in practice, what I would like to emphasize is, as Dr. Dayan said, maybe the Prevention of Terrorism Act came about in the midst of, say, there was a civil disturbance in the north and east, or civil war, whatever you may call it, or the uprising in the south. But my basic position is that is no justification for the Prevention of Terrorism Act as it is. It falls far short of international standards on terrorism. And if you look at the type of offenses, they are the offenses contained in the ordinary law of Sri Lanka. What the Prevention of Terrorism Act tries to do is increases the penalty and ends up in confiscation of property for committing some of these acts that could have been dealt with under the ordinary law of Sri Lanka, so that it's not necessarily connected to terrorism. And like a simple thing is, if you look at the definition in sections 2 and 3, what it says, causing the death of any specified person or kidnaps or abducts a specified person, that is under 2 subsection 1A. I'm just taking an illustration. Now, this particular act or the criminal act is covered by the penal code. The PTA brings it in and just puts it there, which is overbroad, and increases the punishment. The sentencing also can result in confiscation of your property. So it is, I would say, a very draconian piece of legislation, even if you are dealing with a civil uprising or a secessionist war. And it is violative of the fundamental rights of human beings that face that. Some of the striking features of the Prevention of Terrorism Act that revolts against respect for human rights is the admission of confessions. Now, a confession made to anybody above the rank of an assistant superintendent of police is admissible in a court of law when you're tried for prevention of terrorism in the High Court. And the burden of proving that the confession was irrelevant or involuntary is on this unfortunate person who is charged, the accused. He has to prove it. It cuts across the presumption of innocence. It cuts across our very constitution. Let's not talk about international covenants and international humanitarian law. Our very constitution is violated because in our constitution, everybody is presumed innocent. The PTA cuts across that. And imagine making a confession to a person of the rank of assistant superintendent above, it's being admitted. We know the ground situation of impunity, the culture of violence and torture. And some time ago, there were representations made by some of the lawyers that it is not even the assistant superintendent who extracts a confession. There may be a lower police officer who gets the confession by whatever means, and the assistant superintendent signs off to meet the requirements of the PTA, which means, okay, the confession has been made to an assistant superintendent or officer or above, and therefore it's admissible. And we know the famous case of Nallaraj Singarasa, who was convicted purely or only on a confession, and which was in dubious circumstances. So what I say is this PTA, quite apart from being overbroad and providing for situations which could normally be dealt with by the ordinary law of the land, has only ensured that you can give a harsher punishment, confiscate property, by circumventing the laws related to confessions, making all of them admissible. And also it provides for a detention order by the executive. And those are not, in very limited situations, can be reviewable. So you're taken the power to incarcerate a man by giving it to the executive of the country. Originally, it was 18 months. Now, as Honorable Rauf Hakim said, there's a cosmetic change making it 12 months. Why is the need for the executive to be able to control the detention and incarceration of a suspect to begin with? We have heard government after government placing fullest confidence in the judiciary and saying the judiciary, our judiciary is good, they are independent. So what is the need to deprive the judiciary of supervision of a person who is incarcerated under the PTA? Because under the normal law of the land, when a person is arrested, he has to be brought before a magistrate within 24 hours. And then bail is the general rule. He's given bail unless there are strong circumstances. And this order for bail, even if he's refused bail, these can be reviewed from time to time. But when a DO is there, a suspect's right to be granted bail or given his freedom to move about pending the trial is also taken away and given to the executive. Originally, it was for a period of 18 months. It has been now reduced to 12 months. So this again violates the fundamental freedom of a person to be treated fairly because prolonged incarceration itself is torture. One does not have to be physically attacked for torture. So that you have a lot of the international covenants being violated. And I had a case where, in fact, minors were taken. Honorable Rauf Hakim referred to the situation of the Easter Sunday attacks. And Dr. Jayathileka referred to the incarceration of a lawyer, Ijaz Hizbullah. In fact, Ijaz Hizbullah's clan's files was ransacked in his office and taken. Confidential documents of clan confidentiality were taken. And minors, in some cases, were taken away from their parents and questioned. So what about the rights of the child under the convention? So my fundamental position is that the PTA was not needed at all. If at all, it should be abolished. It's not a question of amendment. So I take a more basic position that because of the prolonged detentions without supervision, judicial supervision, where the suspect is at the mercy of the DO, of the detention order by an executive, and where there is several instances of proven instances of torture, cruel treatment. Because the other thing we have to face up to is that we don't have skilled interrogators, not sufficiently skilled. If you take the police officers or whatever, then they lack that techniques and the skill. So the obvious convenient way of extracting information is torture and inhuman treatment. And so when you have the PTA permitting that with impunity, then obviously there are the rights of the accused or the suspect is seriously violated. So considering these two fundamental aspects of the detention order by the executive without judicial supervision and the admissibility of confessions against the presumption of innocence, and the fact that the Prevention of Terrorism Act's definition of what is an offence under it is overbroad, too broad, it's best that the PTA is got rid of lock, stock, and barrel. That is my fundamental position that I take as a lawyer, because there is plenty of scope with perhaps some minor improvements to permit dealing with so-called terrorists, if you define it properly, under the ordinary law of the land, with a proper procedure, with skilled persons, and with a fair judicial due process. The due process is also denied. The person is incarcerated. So my fundamental thinking on this again is that do we really need that the PTA at all? Do we need, you say, Counter-Terrorism Act, as Rauf Hakim said, that too doesn't meet the standards. And there's a National Security Act, which is opaque and hidden for the moment. So whether all these things are necessary at all? If we talk of our society being, after all, a civilized society, a democratic society. And the further point that I would like to make is, if you look at the instances in which the PTA has been used, it has more often been used against the minority communities. It has been used against political opponents. Whereas you have so many people who could have been tried under the PTA with the same yardstick for inciting violence, who have gone free and who are now holding important positions. So when you look at it, it is more the people who have worked it and the purpose for which they have worked it. And successive governments have been guilty of permitting this impunity, especially in applying the PTA, as Rauf Hakim says, willy-nilly for everything. And Dr. Diane Rector says there's a quantum leap today where the PTA has been used in an unforeseen manner, in gigantic proportions, to quell any form of resistance, any form of opposition, however lawful. So, independent of that, my basic thinking is the PTA must go. And let's look at our law and let's look at if there are improvements in it. And we should strengthen our laws to prevent this impunity, torture, and violation of the rights of the people. Thank you.
Thank you very much, Mr. Alagaratnam. Very, very focused onto the very important points of the topics today. Thank you very much. I really hear that what you say, the PTA itself is the real definition, the very definition of draconian law, purely because the way how it's been used and utilized and manipulated in terms of achieving individual goals of a government or people who implement it. And also you made a point of saying that the law itself goes against the general rules of a law of a country in terms of the burden of proving innocence. And that is a very difficult task for a commoner. If they don't have the right links to the specialists, cannot afford the lawyer fees, or even unable to gather evidence to support themselves. Usually, in every country, in every part of law, it is the burden of proving the guilt. It comes to the enforcers or the power handlers. And also you mentioned about Mr. Singaraja, Ijaz Hizbullah, not to forget about the unfortunate incidents of the young poet, Ahnaz Jazib, I think it's 26-year-old poet, just for coming up with a poem. He was actually kept in custody with no access to legal access. So I think the bottom line is that in a country where there is democracy, there are multiple laws to govern the security of the country, especially the Terrorism Act. You do not need a specific window for manipulation of abuses by a government giving the rights well beyond the rights of any security system. And on that note, we all support that actually reform is not enough for the PTA. It should be repealed. And of course, the pressure should come from the international community, and they need to hear and see how inappropriate to have such a law implemented in